Mr. Carr, could you please read this ordinance by title only?
Yes, Chair. Ordinance number 896, an ordinance adopting Chapter 8.54 of the Washington County Code regulating public property with respect to camps and camping.
Thank you. And with that, I'd like to turn it over to our two staff subject matter experts and have them introduce themselves, please.
Thank you. Good morning, Chair, Commissioners. For the record, my name is Jess Larson. I am your Assistant Director in the Department of Housing Services overseeing our Homeless Services Program.
For the record, I'm Courtney Duke-Dreesen, Deputy County Counsel.
We have a brief presentation for you again today, and my role is to help cue up the context for which you are considering Ordinance 896, and that context being our homeless services program delivery across the county and recent and significant expansion in that work. So to get started, as context, our system for addressing homelessness includes multiple strategies under kind of three general approaches for households and residents in need in Washington County. So we have approaches for folks who are experiencing unsheltered homelessness. This would include our outreach workers who help connect people to shelter programs and such. Then we have programs that focus on providing shelter for individuals or helping those who are homeless while in shelter programs. We have a variety of shelter programs that are expanding significantly. In all of those shelter programs, we have services designed to help connect people to behavioral health, recovery programs, employment programs, and ultimately housing. And then in our third lane of service delivery, we are also working to focus our services on providing housing stabilization to folks who are housed but are at risk of homelessness. And that risk can be because of rent burden and the need for eviction prevention services, or it can be a risk of homelessness due to complicating medical and behavioral health needs such that they need ongoing supportive services like resident service providers or case managers to help ensure housing stability. So we provide services for folks in all of these states of housing instability with the ultimate goal to create a unified and connected system that works towards stable housing for everyone. Of course, we don't do this work alone. We do it in partnership with many community-based providers. Here's just a quick snapshot from our website, not the complete list of providers, but that sense of our broad network of providers who have varying different population and geographic expertise and work across multiple kinds of services to help us provide this integrated system of service to our community. This is a quick snapshot of this growth in action right now in Washington County. So I'm going to draw your attention first to the middle bar chart, which shows the change in shelter capacity every day of the year. In Washington County, we had less than 50 shelter beds that operated year-round in 2021, and just 2 short years later, we have more than 400 and growing. In our housing system, we had just about 700 and so, sorry, I'm not adding that up quickly, housing placements that we sustained year over year, and now we've more than doubled that capacity, and it continues to grow. So people have a place to move from shelter into housing. And this growth in capacity is demonstrated for the first time in our point-in-time count, where we see a decrease in chronic homelessness happening in our community, and that is the slide on the far left showing the change in unsheltered homelessness specifically from 2021 to 2023. Of course, we are doing this with increased resources approved by our voters in the metro region, and this is a quick bar chart that shows you a snapshot of the change in our funding and resources to invest in these services from 2021 to our current budget approved year. And that's both in the scale of that resource available and also the diversity of services we're able to provide to create that complete system of care. We're also excited to be working with some one-time funding carried over from the build out of that supportive housing services measure. These resources will help us to make important infrastructure investments in our system, specifically in permanent shelter sites that are under development or pre-development, working towards breaking ground soon. And next, we'll be working on access centers, places where unsheltered people will be able to access services in the daytime and get connected to all of the services described previously. So going back to this slide and helping orient the conversation before you today, this Ordinance 896 is a specific focus on how we in Washington County respond to the reality of folks living unsheltered in our community while we're working to connect them to the services that we have shared today. And then with that, I will pass it over to my colleague to continue the presentation.
Thank you, Jess. So my role for you here today is to talk you through the legal framework and the actual context or content of Ordinance 896, which we are asking you to consider for adoption today. So Ordinance 896 arose in response, in part, to some decisions that came out of the U.S. Court of Appeals for the Ninth Circuit and a House bill that was adopted by the Oregon legislature in 2021. So the first federal court case is a case well known to your board at this time, at this point in this process, but it's known as Martin v. Boise, and that is the case that stands for the proposition that the Eighth Amendment of the United States Constitution, which prohibits cruel and unusual punishment, prohibits the criminalization of the unavoidable consequences of being unsheltered or homeless when the person doesn't have access to alternative shelter. The second case out of the Ninth Circuit is a case called Johnson v. Grants Pass, and that case did a number of things, but for our context today, I want to highlight two things the Johnson court said. The first was that they clarified that the sleeping in the context of Martin includes sleeping with rudimentary forms of protection against the elements. And what that means is that a regulation that regulates camping on public property can't say that someone sleeping outdoors can't have some forms of protections like sleeping bags or blankets against the elements because they live outdoors. The second thing the Johnson court clarified was that the prohibition against the criminalization of homelessness applies to civil citations and penalties when those civil penalties are closely intertwined with criminal penalties or punishments. Finally, in 2021, the Oregon legislature adopted House Bill 3115, which says that any city or county that regulates sitting, lying, sleeping, living outdoors must be objectively reasonable as to time, place, and manner with regard to the person experiencing homelessness. So with that legal context in mind, here's a quick snapshot of our development on this Ordinance 896. We were first before the board in January 10th of this year to talk about best practices and ask your board for some feedback on broader policy questions. We came back on April 4th in work session to walk you through the actual contents of a proposed ordinance. After that presentation, your board directed staff to begin community feedback sessions, which happened between May 23rd and June 2nd of this year. We were here just a few weeks ago for our first reading and this presentation, and we are here today for the second reading and public hearing.
So a quick snapshot of that community engagement work we did to receive feedback from our community across the county. And we specifically focused on reaching residents in unincorporated Washington County, because that's where this ordinance will apply. So we had three in-person sessions and also a virtual session. And during that period also had an online survey available to receive feedback from our community.
All right, so now to walk through the actual content of the ordinance before your board for consideration today. So as has been the case since April 4th when we first walked through the ordinance with you, the ordinance is structured to say that when shelter or camping is prohibited on public property in unincorporated Washington County when shelter is available to the person in the camp or camping. The ordinance then goes on to provide that when shelter is not available to the person in the camp or camping, that activity would be regulated by reasonable time, place, and manner restrictions. So first, as to time, when shelter is not available, Ordinance 896 will regulate camps and camping on public property in unincorporated Washington County to a 5-day calendar period. As your board is aware, we arrived at this 5-day period for a number of reasons. The first being that in our experience over the last several years in managing encampments and individuals who are camping on public property, we found that it takes 3 to 5 days to reach and connect these individuals with the outreach workers and the services and programs that Jess spoke about at the beginning of the presentation. Notably and importantly, the 5-day period is also developed in partnership and with full support of the Washington County Sheriff's Office as the proper balance of resources to enforce the time regulation. And then finally, we believe that the 5-day period is reasonable. We have to always remember that this work is going to be judged by its objective reasonableness, and there's already a basis in Oregon state law and in county adopted policy to give 72 hours or 3 days notice before removal of an established encampment. So the 5 days is in line with that existing precedent. Next, when shelter is not available, Ordinance 896 will regulate the places where camping can or cannot occur. So first, I want to speak about the cannot occur places. The ordinance does incorporate a number of places where camping would never be allowed, even if there is no accessible shelter to the individual. These places include tax foreclosure properties within 500 feet of designated shelters, locations providing services to houseless individuals, schools, daycare facilities, and family care providers. And then also on any property designated or operated by Clean Water Services or any agency of the state of Oregon as a riparian corridor, floodplain, drainage area, water quality sensitive area, vegetated corridor, sensitive habitat, or other significant natural resource area. As we discussed with you when we were here in June, we have also since in direct response to our community feedback sessions added one additional no place, and that is a regulation that would prohibit camps within 500 feet of any camp or encampment that had been regulated under this ordinance, should it be adopted for reaching the 5-day period, or removed under the Washington County homeless camp removal policy, or regulated under any other authority of Washington County. So we heard from the community quite a bit questions about how far would a camp or camper have to move if it was regulated, and we didn't have a clear answer for that, so we added that expressly in the ordinance. So that would leave some permissive places where camping would be allowed subject to the time and manner regulations, and those places would be the public right-of-way with some additional restrictions that I'll talk to you about in a minute, and then other public property that's open to the public in unincorporated Washington County that doesn't otherwise fall in one of those no places. Before I move on to the manner regulations, I did want to take a moment to address some of the questions that we heard that were raised during our first presentation to you in June, and specifically why the ordinance incorporates a 500-foot regulation instead of an 1,000-foot or some greater foot regulation. Again, as we approach this work, we've had to balance trying to address or regulate encampments that may be near other properties that are designated for a specific use, and addressing the health and safety concerns that may arise by those uses happening next to each other, with the legal framework that says we can't eliminate all property and the regulation must be reasonable. So as we started to look at what sort of regulations that might be, we landed on 500 feet as something that created a consistent and significant amount of space without eliminating too much public property from where permissive camping might occur if shelter isn't available. I also think it's notable that the cities of Beaverton, Hillsborough, Forest Grove, and Tigard have all incorporated 500-foot regulations. So I think this creates some consistency and predictability and enforcement, not only for our unhoused community, but also our business and housed community. There was also some questions about whether the ordinance would prevent or impact the siting of shelter or shelter services. Nothing in the ordinance defines or impacts the citing of those types of services. Should those services be cited and encampment gets established, or a camper comes near a shelter or houseless service provider, then the ordinance might apply if we're talking about unincorporated Washington County. If we're in a jurisdiction, an incorporated city with their own ordinance, that city's ordinance would apply. And then finally, we heard some questions about why we hadn't included senior care centers or assisted facilities in the ordinance. Each of the designated uses where we've added the 500-foot regulation are defined uses of property that exist in the Washington County Community Development Code. We do not have defined uses for assisted care facilities or assisted living facilities. So again, in our efforts to make sure this ordinance is reasonable, that kind of use is not included for the proximity regulation, and at this time, the ordinance wouldn't affect encampments occurring in those locations specifically. Finally, our manner regulations. When shelter is not available, Ordinance 896 will regulate how camping can occur in the permissive places for the allowed time period and in the allowed permissive places when shelter is not available. Again, these are things that are very familiar to your board at this time. They include things like allowing only essentials for living outdoors, limiting the size of an individual camping area to no larger than 144 square feet, and prohibiting actions that may cause health or safety risks, such as accumulation of waste, non-cooking use of fire, dumping of water that's used for cooking or bathing, digging or trenching, or any criminal activity are prohibited. As I mentioned, because the public right-of-way in unincorporated county, Washington County does remain a possible permissive place, we added additional manner regulations that would apply in addition to these things to the right-of-way. These are things like no obstruction of the travelway, sidewalk, bike path, or bike lane, no obstruction of access, be it emergency, non-emergency, or ADA, not allowing encampments in areas where there's no curb or physical barrier between the camp materials and the area intended for traffic, and then finally no allowing camping under bridges, in viaducts, or in culverts to protect that public infrastructure. So again, this brings us to the close of our presentation. We are here asking you to consider enactment of the Ordinance 896.
And with that, Commissioners, I would ask if we have a motion to adopt Ordinance number 896.
So move.
Second.
We have a motion and a second. Clerk Moss, could you please take the roll call?
Certainly, Madam Chair. Commissioner Treese,
Yay.
Commissioner Fye, Commissioner Willie,
Aye.
Vice Chair Rogers,
Aye.
Chair Harrington.
Yes. The ordinance passes unanimously 5-0.